Hi, I'm Kelly Longtin from Kelly Longtin Law, and today I want to talk to you about your estate planning checklist just to facilitate that multi-generational wealth transfers and make sure that they happen according to your wishes. Now, studies estimate that 70% of family wealth is lost by the end of the second generation and 90% lost by the end of the third generation. Now, to help your loved ones avoid becoming part of that statistic, you need to educate and update your extended family about your wealth transfer goals and the plan that you have put in place to achieve these goals. You should consider communicating the following information to your family to ensure that your loved ones understand and will be prepared to carry out your wishes during a very difficult time. You want to communicate your net worth, or at least a minimum, a broad overview of your wealth. You want to communicate your financial wishes for burial or cremation or memorial services. You want to communicate your estate planning documents that you've created and the purpose that each document serves. So let's just review what some of those documents may be for you. First, we have your durable financial power of attorney. And this is where you designate who will be in charge of managing your accounts and your property if you're living but unable to make decisions. And it also states what authority your chosen decision maker will have. And it also avoids the process of going through a legal conservatorship, which is the court supervision of your financial affairs. You will also need a medical power of attorney. And in the medical power of attorney, you will name who will be in charge of making medical decisions for you if you are unable to make those kinds of decisions for yourself. By having this in place, it will help your family to avoid guardianship, which is a court process where someone is appointed to make these medical decisions for you. And those can often be very controversial between family members. You may have an advance directive or a living will, and this is where you can clarify your wishes regarding life-sustaining procedures. Most likely, and you should have, what's called a HIPAA form. So this is the Health Insurance Portability and Accountability Act authorization form. And it just simply names the person or the people that you have chosen to access your protected healthcare information. Although they can't make decisions for you, they are entitled to receive information about you. Now, by implementing a revocable trust, you'll be able to avoid guardianship or conservatorship of your property during your life and also be able to avoid a probate at your death. This will also keep your financial wishes private, and you can also minimize delays, costs, and any government involvement overall, making things easier for your loved ones. You will have a pour-over will or a last will or a last will and testament, and that's a catch-all for all of the money and property not transferred into a revocable living trust or designated by beneficiary designations before death, and it can be the primary means to transfer money and property in your sole name if you're not using a revocable living trust. Now, some people will choose to implement an irrevocable life insurance trust. Now, this trust removes life insurance from your taxable estate and provides immediate access to cash for your loved one's needs, administration costs, and taxes after you've passed away. Now, there are also other advanced planning tools that allow you to protect money and property from creditors and predators, outside influences, and ex-spouses. Now, proper planning can enable you to provide charitable gifting and also allow you to minimize any taxes that may be due. Now, when it comes to estate planning, the first thing that you need to consider is who you will name to make decisions for you when you die or you're incapacitated or otherwise unable to make decisions for yourself, both financially and medically. You'll need to decide who will help you when you are living by naming agents in your durable or financial power of attorney and in your medical power of attorney. You'll also need to name a successor trustee of your revocable trust and any other trust that you've created. That way they can step in during an incapacity and then later when you pass away. You'll also have to name a personal representative or an executor for your last will and testament or a pour-over will. Now I want to take a minute to talk to you about discretionary trust and how they work as an estate planning strategy and the benefits that a properly drafted lifetime discretionary trust can have for your family. It can allow you to foster educational opportunities for your loved ones and provide asset, divorce, and remarriage protection, and protect special needs beneficiaries, and allow for professional account and property management, and also to minimize estate taxes at each generation, and to create a lasting legacy for future generations. You really need to look at your goals and intentions for inheritance, what the money is and is not to be used for. For example, maybe it's education or charity or business opportunities or retirement instead of vacations and Ferraris. And who will be the trustee of any lifetime discretionary trust created for your family members and why you've selected them. You want to then make sure that you communicate to your loved ones the location of important documents. Now, this should include how to access your digital assets such as social media, online bank accounts, and crypto assets as well. You want to notify your family about your key advisors and their contact information. So that'll be your estate planning attorney, your financial advisor, your CPA, and your insurance agent, or some other maybe spiritual advisor that you use. Your professional advisors are well positioned to help you discover your wealth priorities and goals and objectives, and then communicate this information to your family. This will prepare your family to receive your accounts and property and not be left to figure out your intentions on their own, which could, as statistics have shown, risk losing them all. We can assist you with determining your wealth transfer goals, creating a plan to achieve these goals, and effectively communicating this information to your loved ones. I want to thank you for watching. I'm Kelly Longtin from Kelly Longtin Law.